Children, case number 22-222.
Right, we are back on the record. First things first, Mr. McFarland, do you have anything on the issue of the review? That was the pretrial review that was begun back on the 18th and continued to today. Any objections to the admission of the court reports or anything else?
No, Your Honor. And my client, I did have a breakout with him, and we were agreeable to adjournment to October 17th at 9. But there was a more recent development by the attorney for the agency.
Yes, and I was briefed on that during a sidebar, but I'll let Mr. Amadeo take the lead on it.
Thank you, Judge. We'll make an oral motion at this time to dismiss the case against Mr. Young without prejudice. I don't see any risk of harm right now, and I think we just take up the court docket. So if we feel the need to revisit, I would ask that the dismissal be without prejudice, but at this time, we would like to remove it from the docket.
Your position, Mr. McFarland.
Will not disagree with the dismissal, Your Honor.
Your Honor, for the permanence for the children, the NY child is hoping for a step-parent adoption for his permanence goal, and I have advised his family that that'll have to be pursued in another way, as the law in Michigan requires that we establish a risk of harm to the child, and the incarceration for Mr. Young is preventing us from showing any risk of harm. So, and I also have no standing to file on my own, so I that's where I stand. Thank you.
All right. Well, as the court,
Can I comment on that?
no, you can't. You can have an opportunity to talk to your attorney again if you need it. But the request is to dismiss the case against you.
Okay.
Do you have a problem with that?
No, I was gonna say something about the adoption of my other son. I didn't have a problem with that if that's what she wanted to do.
All right. Well, I'm sure they'll be in touch.
Thank you for that.
All right. Given the circumstances, and I'll say, I'm sure some of this was as a result of me being briefed at a sidebar on this, but there's an understanding effectively, and the information is available to all parties concerned. Mr. Young is currently incarcerated with a very high bond on very serious felony charges. As a result of that, he has no access to the children and no ability to present a risk of harm as a result of the allegations in those criminal proceedings, which are reflected in the petition that was filed against him. So for those reasons, there is no emergent necessary circumstance that would require the court to continue pursuing adjudication or allowing DHHS to pursue adjudication of Mr. Young, given the circumstances. I will grant the request to dismiss the petition against Mr. Young without prejudice, understanding that if it does arise, or if a risk of harm does arise, wherein that becomes necessary out of some of the same or similar facts and circumstances, then obviously the court is here and available to entertain that in order to adequately protect the children. But as of today, they are adequately protected, and we do not need to use the intervention or the resources of the court any longer. The pretrial and jury trial will then be taken off the books. The court will enter that order indicating that Mr. Young has been dismissed as a respondent without prejudice as of today. And as far as our proceedings go, we will simply have the previously scheduled dispositional review hearing and permanency planning hearing October 17th, 9 a.m. as it relates to Mother's case. And of course, we'll continue to review things as it relates to the children as well. All other prior orders will remain in effect, full force in effect, pending those proceedings. Unless there's any questions, that's all.
Your Honor, so Mr. Young and I are excused from further proceedings on this, correct?
Yeah.
Thank you.